motion to suppress. Council ready to proceed? Ms. Mulligan?
Your Honor, I am ready to proceed. I realize that I had left the exhibits on my desk at the office, so I'm gonna have somebody run them over here to
Okay.
me. But, if I can have just a moment to make that phone call
All right.
and,
Is the defense ready also?
Yes, Your Honor.
Okay, so, yeah, just
I'm sorry.
let me know when you get it, okay?
Hi, I was trying to get to Linda, but I can't get through to her. I left the exhibits for my hearing on my desk. And I need somebody to run them over to me. Okay, oh, I'm sorry. I could, let me call Katrina, I'll call Katrina. Okay, thanks, bye-bye. Hi, I have a request for you. I can't find Delinda, but I'm over in O'Donnell's for a suppression hearing, but I think I left the exhibits on my desk. And I need somebody to run them over. One is a 2255, it's like a, it's a form, a multiple copy form, and then there are two pieces of paper that each have exhibit stickers on. Do you see that? You can bring, yeah, bring them as well, thanks. There should be two copies, each have a sticker on them, and then one that's just a form that has a sticker on it. Use the best, thanks. Oh, thanks, bye. That's what I get for being here. Are you trying to show me something? You can only get in there for a limited amount of time.
Okay, this is the one you sent January 17th, so how long do I have to access it?
I don't know the answer.
I mean, that's like barely 2 weeks. So can you resend it?
I will. I'll
Thank
make
you.
sure that it's,
Okay, thanks.
All right, Ms. Mulligan?
Your Honor, the state is prepared to respond to the defendant's motion to suppress and show the court that the defendant's consent to the chemical test or submission was voluntary. And I would call Patrolman Austin Turner.
Step forward. Raise your right hand, please. You swear testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. All right, have a seat.
Good afternoon.
Good afternoon.
Could you tell everyone your full name, please, and spell your last name for the record?
Austin Charles Turner, Turner.
And what is your occupation, sir?
I'm a patrol officer with the City of Eastlake.
How long have you been with the City of Eastlake Police Department?
It'll be 5 years in a couple weeks.
Okay. Can you briefly describe your background and training that qualified you for the position that you currently hold?
Yes, upon getting hired by the Eastlake Police Department, I was sent to the Ohio State Patrol Police Academy. That was 21 weeks of your basic State of Ohio Police Academy.
And following your graduation from that, did you become a certified peace officer in the state of Ohio?
Yes, I did.
Okay. And you immediately went to work for Eastlake Police Department? Yes?
Correct. Yes.
And can you briefly describe your responsibilities as a patrol officer there with the department?
Yes. As a patrol officer, you were required to patrol the City of Eastlake, respond to calls for service, investigate crimes ranging whatever, occurs in the City of Eastlake.
And you do that in a marked police cruiser?
Yes.
Okay. Do you have a partner typically in that cruiser with you, or are you in alone?
Alone. I had a partner for field training, and then you're alone after that.
And then you wear a uniform similar to what you have here in court today?
Yes, similar.
Okay. I'm going to go back to January 7th of 2023. Were you working that day?
Yes, I was.
Do you recall what shift you were working?
Yes, I was on night shift.
And was there a time that a call came in regarding a crash, an automobile crash, just after midnight on Lakeshore Boulevard?
Yes.
Okay. Do you recall what time that call came in?
Yes, 12:26.
So just after midnight?
Correct.
And did you respond to that?
Yes, I did.
How quickly did you get there?
About 2 minutes, I believe.
Okay. And when you got there, did you encounter, ultimately, when you saw the crash, a person by the name you later found to be Edward Swales?
Yes.
Okay. And do you see Edward Swales in the courtroom here today?
Yes, I did.
And would you point him out for me, please?
Yes, he is the male sitting right to the left of you.
If the record can reflect that he is identified, the defendant.
Yes.
And where there on Lakeshore Boulevard did you see Edward Swales? Where was he?
He was on Lakeshore Boulevard in a motor vehicle just by Reeves Road.
Okay. And where in the vehicle was he?
He was in the driver's seat, but his legs were outside of the vehicle.
Was there anyone else in that car when you met him?
No.
Okay. And he was in the driver's seat, was his head upright or was it laid down on anything?
His head was upright.
Okay. And did you note any injuries immediately when you saw him?
Yes, he had a large laceration to his upper left, above his eye.
Did you have any conversation with him there at the scene?
Yes.
Did you ask him any questions?
Yes.
What did you ask him when you first arrived?
First, I assured him that a ambulance was on the way for his injuries. I asked him his name. I asked him if he was the owner of the vehicle. I asked him where he was coming from, where he was going to. I asked him how much he had to drink that evening. And I asked if there was insurance on the vehicle.
When you asked him his name, what did he say?
He said his name was Edward Swales.
And when you asked him for his driver's license, what did he say?
He said he does not have a driver's license.
When you asked him where he was coming from, what did he tell you?
He said he was coming from a bar named Floods in Euclid, and I asked where he was heading to, and he said his house in Bedford Heights.
Okay. And did you have, as part of your duties as a reporting officer there, an impression from that response as to the direction of the investigation.
Yes,
What was that?
that he admitted to consuming alcohol, and due to a bar in Euclid and trying to get home to Bedford Heights, ending up where he did in Eastlake made no sense as far as the route traveled.
Okay. And then you asked him how much he had to drink?
Correct.
What did he say?
Objection.
Overruled.
He said he had 2 drinks.
When you asked him if he had insurance, what did he tell you?
No.
Did he say anything about what was in the car?
Yes, he said there was weed in the vehicle.
Okay. And when you were having this conversation with him, were his answers responsive to the questions that you asked?
Yes.
Okay. And about how long did this conversation take place?
About 3 minutes.
Okay. Did he ask you for anything?
No.
Okay. Did you ask him about the car that he was driving?
Yes.
And what did he say about the car he was driving?
That it was his cousin named Tyler's car.
And did he ask you to call anyone for him?
Yes.
Who did he ask you to call?
His fiancee, Dominique.
And you said that this took place over the course of just a few minutes?
Yes, before the
Conversation.
ambulance arrived.
And how did this conversation end, or why did this conversation end?
Because the ambulance arrived and he had a obvious injury that needed to be taken care of, so that took precedence.
Okay. And was he taken from the scene by the ambulance?
Yes.
Did you see him again that same evening?
Yes.
Where did you see him?
At Lake West Hospital.
Okay. And about how much time passed from the time you first saw him at the scene until you got to Lake West Hospital, if you remember?
If I had to give an estimate, 15 to 20 minutes.
Okay. And you said you saw him at Lake West Hospital. Where in the hospital was he?
He was in a room by himself, meaning no other patient in the emergency room.
Did you go into that room?
Yes.
Okay. Was there anybody else in that room besides
There
Mr.
was-
Swales and you?
Numerous medical personnel in and out of the room.
And when you saw him in that emergency room, how was he positioned? Where was he in the room?
He was in a hospital bed. When I first arrived, he was in a more of an upright position, laying in the hospital bed, but was more, 45-degree.
Upright position, how would you describe where his head was relative to his body then? What do you mean?
His head was laying against a bed, but in 45 degrees higher than his lower body.
And what did you note about his appearance when you first saw him at the emergency room?
They had placed a neck brace on his neck and had a wound bandage over basically his face area for the wound over his left eye.
And when you first got in the room, did you talk with him?
Yes.
Okay, what was the conversation? What did you say?
I asked again where he was coming from and where he was heading to. He gave me the same answer, that he was coming from floods in Euclid going to Bedford Heights. I again asked him how much he had to drink, and he said 2 shots this time. I asked him if he had anything to drink other than the 2 shots at floods, and he said he and about 6 or 7 buddies drank a bottle of Patron Anejo before going to floods.
Again, with the questions you were asking, were his answers responsive to the questions that you asked?
Yes.
And did you ask him about anything that was found in the car?
Yes.
What did you ask him?
There was a bottle of a Heineken beer bottle on the driver's side floorboard that had suds coming out of the bottle. I asked him why that was there. He said that he must have drank it on his way to floods.
And at this point, Was there anybody else in the room during this conversation, if you recall?
Yes, medical personnel.
And did you have, can you describe what his voice was like? How he was talking?
Slightly slurred,
Objection.
Overruled.
slightly, slurred, slow and lethargic.
Was there any verbal indication from the defendant that he was in pain? Did you hear moans or screams or
No,
shouts?
no,
Though he did appear injured, clearly.
yes.
So after you had this short conversation with him, then what did you do?
I read him the back of the BMV 2255 form, specifically the section for the consequences of refusal of a chemical test,
And why did you do that?
because it had probable cause to believe that he was committing the offense of operating a vehicle under the influence, and that is the normal procedure.
Okay. I'm gonna, if I may approach, Your Honor?
Yep.
I'm showing what's been marked as State Exhibit 1. Can you tell us what that is?
Yes, this is a State of Ohio BMV 2255 form.
And is that the same form that you used to read to Mr. Swales there on the 7th of January, 2023?
Yes,
And does it have the same section that you read aloud to him?
yes,
And what did you read? Could you read it for us here today?
yes. Consequences of test and refusal, RC 4511.192, must be read to OVI/physical control offenders. You are now under arrest for, you specifically state the offense under state law or a substantially equivalent municipal ordinance for which the person was arrested,
What did you say to him in that particular circumstance?
operating a vehicle under the influence.
Okay, then continue.
Operating a vehicle under the influence of alcohol, a drug, or a combination of them. Operating a vehicle while under the influence of a listed controlled substance or a listed metabolite of a controlled substance. Operating a vehicle under underage alcohol consumption or having physical control of a vehicle while under the influence. If you refuse to take any chemical test required by law, your Ohio driving privileges will be suspended immediately, and you'll have to pay a fee to have the privileges reinstated. If you have a prior conviction of OVI or operating a vehicle while under the influence of a listed controlled substance or a listed metabolite of a controlled substance, under state or municipal law within the preceding 20 years, you are now under arrest for state OVI. And if you refuse to take a chemical test, you will face increased penalties if you subsequently are convicted of the state OVI.
Is that what you read to him?
Yes, there is a second section as well.
Did
Just
you
under
read the second section to him?
Yes, because the second section's, you don't read for physical control, but it wasn't a physical control, so yes, the second section was read.
Okay, and what does that say?
If you take any chemical test required by law and are found to be at or above the prohibited amount of alcohol, a controlled substance, or a metabolite of a controlled substance in your whole blood, blood serum or plasma, breath or urine, as set by law, your Ohio driving privileges will be suspended immediately, and you'll have to pay a fee to have the privileges reinstated. If you take a chemical test, you may have an independent chemical test taken at your own expense.
And that was read to Mr. Swales on the 7th of January.
Yes.
Was there anything else from that form read to him? Did you read anything else from that form?
No.
to him? Okay. Was he alert when you read that form to him?
Yes.
At any time that you were in that hospital room with him, was he sleeping?
No.
When you read that form to him, did he interrupt you?
No.
Did any medical personnel interrupt you?
No.
Did he ask you any questions?
No.
After you read that to him, what did you say to him?
I asked him if he would submit to a chemical test.
And what did he say?
He said that yes, he would, because it's obvious that he had been drinking.
And as part of that form, the front of that form requires you to fill it out and to get the person's signature agreeing to take the test, correct? Or the form was read?
Yeah, it's a signature to say that the, form was read to him.
Okay. Was there anybody else in the room when you read that form to him?
Yes.
Who was in the room?
Lake West quarterback paramedic Ashley Adams.
And Ashley Allen, you know her to be a Lake West employee, correct?
Yes.
Um, I'm going to hand you what's been marked as safe exhibit number 2. Do you recognize that?
Yes.
What is it?
It is the specific, a copy of the specific 2255, the front page of it from the form that I read and was filled out for Mr. Swales.
And does it bear his signature?
Yes.
Did you see him sign it?
Yes.
How did he sign it?
I had a clipboard with the form on it. I handed it to him as well as a pen, and he signed it.
And he signed in the appropriate place?
Yes.
And he signed on the line?
Yes.
And it bears the signature of the Lake West employee that witnessed?
Yes.
And it bears your signature as well?
Yes.
Thank you. Did you ask him anything else at that point?
I asked for a signature for a consent to release medical records as well.
Okay. And what exactly did you say to him to ask him that?
I asked him if,
The form that was presented to Mr. Swales on the 7th of January.
yes.
Okay. Does it bear his signature?
Yes, it does.
Did you see him sign it?
Yes.
Is his signature in the appropriate place?
Yes.
And it isn't on a line? Is it on a line?
Yes.
Did he ask you any questions about that form?
No.
Or about your asking him to sign that form?
No.
So, after these forms were signed, then what took place in the room?
I alerted a LPN at the hospital that he submitted to a chemical test and asked for blood and urine.
And do you recall the name of that nurse that you,
Yes, Nikki Corfius.
and what was the response that you got from her at that stage?
Yes, she verified with Edward that he was submitting to a chemical test and said that she had to do a blood draw for their medical records before she could provide a blood draw for my records.
Did you object to that?
No.
Okay. And did she do that? Did you see her withdraw blood from him?
Yes.
And,
He opened up the packaging for another draw for, it has to be specific for our records. They have to use a non-alcohol swabbing wipe so it doesn't dilute the draw. So she opened up that packaging and proceeded to attempt to draw his blood.
did you watch that?
Yes.
Okay. And was that accomplished? Did she withdraw blood?
No.
And what did you see her do?
She attempted, say, 2 to 3 times and then said that she can't find a good vein to draw his blood from.
As she was doing this, attempting to find a good vein to draw, did you note Mr. Swales' reaction?
Yes.
How did he react?
He didn't say anything. He made a moan or two when she had to poke him a couple times, which is common with, getting poked by a needle. But that's the extent of it.
Did he tell her to stop?
No.
Why did she stop? Do you know,
Because
if you know, who made the decision for her to stop?
she made it herself.
And what happened next?
She said, she told me she was not able to get blood. I asked her if she would be able to get urine.
And what'd she say?
Yes.
Okay, so in order to effect that, then what happened?
She grabbed the proper urine container and provided it to Mr. Swales. Well, she asked Mr. Swales if he had to urinate. At that point in time, he said he did not.
And again, what was his position in the room when he was handed this bottle?
Still in the same hospital bed?
Okay. Was he under covers?
Yes.
Okay. Was there anybody else in the room that you recall?
At that specific time, no.
Okay. And when he said he couldn't urinate, then what happened?
She set it on a table in the room and proceeded to do her normal duties with other patients and coming back and forth.
And what did you do?
I stood in the room.
Did anybody else come into the room after that?
Yes.
Who?
His fiancee Dominique, who I called on the way to the hospital, arrived.
And did she greet Mr. Swales in that room, in your presence?
Yes.
What did you do when she came?
I stood in the room still, but more towards the doorway and let them conversate.
And for about how long were you in that room then after that? What happened next?
After Dominique arrived, probably about 5 minutes, he alerted that he needed to urinate.
Okay. And how did he alert that he needed to urinate?
He told Dominique.
And what did Dominique tell you, or could you hear him
No,
say that?
I could hear him.
Okay. And when you heard him say that, what did you do?
I alerted the nurse, Nikki, that he was ready to urinate.
And did the nurse come in the room?
Yes.
Okay. Then what happened?
Then she grabbed the urine container, handed it to Mr. Swales, and
Did he grab it with his hand?
Yes.
Okay. And then what happened?
He placed it under his cover, sat more in an upright position, proceeded to urinate into the bottle.
Okay. And was it your understanding that this was accomplished under the covers?
Yes.
Okay. You did not see his penis or the urine coming out of his penis?
No.
Okay. But did you see the jar come out from under the covers?
Yes.
And how did it come out? Who was holding it?
He was holding it, but he handed it to Nikki, and it appeared to have urine in it.
And what did you see Nikki do?
She proceeded to package it into the proper urine specimen packaging that is supplied by the hospital.
And part of that collection process was noting the time that it was collected?
Correct.
What time was it collected?
At 2:11 a.m.
And ultimately, where did that specimen go?
It was packaged into the correct box. She initialed what she needed to, and then handed it to me.
Okay. And what did you do with it?
I cleared Lake West Hospital, went back in my marked patrol car with the urine sample, went directly back to the police station, finished packaging it into evidence, which is just sealing the sides with tape and initialing it, and then it was placed in the lab refrigerator.
Okay. During your interaction with Mr. Swales, did you make him any promises about what was going to happen?
No.
Did you threaten him in any way?
No.
Did you coerce him into
No.
providing the sample?
No.
Did he appear to be coherent the whole time you were in his presence that night?
Yes.
From the time you read him the form and asked him if he would submit the sample, to the time he ultimately urinated in that jar, how much time passed, would you say?
If I had to estimate, 15 minutes.
during that 15 minutes, did he talk to you about his decision to provide a sample?
No.
I don't have any more questions.
Cross-examination?
Thank you, Your Honor. You just stated that you, were only in the room for about 15 minutes from the time you showed the defendant the form until the time that he gave a urine sample. Is that your testimony?
That I showed, no.
Isn't it true that you testified that at around 12:26 is when all this started to happen, correct?
When the accident happened, correct?
And it wasn't until 2:11 that you got a urine sample, correct?
Correct.
At the time you took the urine sample, was Mr. Swells under arrest?
The back of the
It's a
BMW,
yes or no question. Was he under arrest when you took his urine sample?
no.
Did you ever tell Mr. Swells that he had a right to refuse to this test?
Based on my reading of the back of the form, it covers that.
Do you have any training in the medical field, like as a nurse or EMT or any background in medical?
No, just basic,
It's just a yes or no question. Do you have any background in the medical field? Yes or no?
no.
Okay. So you have no ability to make a determination as to whether or not Mr. Swells was in a physical and mental condition to give voluntary consent to a medical degree of certainty. Is that correct?
No, I didn't threaten. I read the back of the state required form.
Well, on that form, one is told that if they do not submit to the test, they will be suspended, correct?
Yes, that's a consequence, yes.
Okay. Isn't it true, though, that this Form 2255 doesn't really allow for you to take blood? It's for a BAC or something other than blood. Is that true?
You kind of lost me, I'm sorry.
On the form that you read to the defendant, in that form, is he consenting to a blood test?
I'm going to object as to the officer's legal analysis of what that.
Well, it's a word on the page or not. Does the form
Wait,
say that they can submit to a blood
wait,
test?
Wait, there's an objection, and I have to rule on that.
I apologize, Your Honor.
Okay? Does the form not say that it's asking them to take a breath test, a blood sample, or a urine sample?
That is my question.
Okay. Does it say that?
It says submit to a chemical test and includes those three options.
And that's what's on the form, right?
Correct.
Okay. So your question is whether that's on the form?
Yes.
Okay, it's overruled.
Yes,
And when you read this form to Mr. Swells, what is it that he believed he was submitting to? What type of test?
I'm gonna sustain that.
a chemical test.
Oh, wait, it's sustained. Wait for another question.
I'm sorry.
Okay. When you read this form to Mr. Swells, did you convey to him that he was submitting to a blood, urine, or breath test?
Did I differentiate?
Well, you're saying he voluntarily consented, correct?
I asked him if he would consent to a chemical test, to which he said yes.
Okay, you didn't explain to him what that meant, whether he was gonna have to give a blood, urine, or just a breath test. Did you explain to him exactly what he was submitting to?
Yes, a chemical test based on the reading of the back of the form.
Okay, so you did not explain to him what a chemical test is. Is that your testimony?
I would say that the back of the form does its explaining by itself.
Okay, so did you confirm that Mr. Swells understood that he was gonna be subjected to a blood test?
Yes, it's covered in the back of the form.
Okay. Did you actually take blood from Mr. Swells?
I'm not a medical professional, I can't take blood.
Okay. Did Mr. Swells submit to a blood test?
Yes,
Was he told that he would be given urine when he signed the form?
specifically, he
Yes,
was told that he's
specifically,
consenting to a
did,
chemical test.
okay. So it's your testimony that Mr. Swells was not for sure what chemical test he would take. Is that correct?
Objection.
The form says what the form says. The testimony is the officer read the form to Mr. Swales that advised him that he would be subject to a chemical test, BAC, blood, or urine. So I'm not, he's testified over and over that he read that form, and then he testified that Mr. Swales signed the form. So where are you going with this?
I guess I'll save that for my closing statement.
All right.
You just stated that you have no training in taking bodily fluids, correct?
Correct.
You have no medical training, correct?
Correct.
And on the scene of the incident, did you investigate into the other car? Whether they were drinking?
Objection, relevance.
For the purpose of this hearing, what's the relevance of that question?
Well, it goes to a lot of the testimony that he gave on the scene as to why he directed his investigation to Mr. Swells and not anyone else.
Okay,
It goes to
but,
probable cause as well, to determine whether or not Mr. Swells was in fact the one drinking and driving and causing an accident.
okay, well, you can ask any question you want with regard to Mr. Swales' case, but we're here for a motion to suppress specifically on limited issues to Mr. Swales, not to the investigation of the scene, only as it relates to Mr. Swales.
You admitted that Mr. Swells had a laceration above his eye at the time that you encountered him on the scene, correct?
Yes.
And it's your testimony that these types of injuries will still leave a person able to give voluntary consent.
I'm sorry, can you repeat?
Yes. Based on your interaction with Mr. Swells, you saw that he was badly injured and bruised, but you still proceeded to believe that he could give voluntary consent?
I wouldn't agree with that. I said a laceration, not badly injured and bruised.
You did state that Mr. Swells' speech was slow, slurred, and lethargic, correct?
Yes.
Are those the indications of a person that is in a position to give voluntary consent?
Yes.
You also mentioned that you were on the scene for quite some time, right? You interacted with Mr. Swells, you asked him several questions, correct?
Yeah, I wouldn't say quite some time, but yes.
And yet you chose not to administer a BAC test on the scene, correct? Less intrusive.
On the scene,
Sorry?
we don't have the ability to administer a chemical test on the scene of a accident.
Okay. So what about when you got to the hospital? You didn't think that it would be a good idea maybe to do a less intrusive BAC test?
The hospital does not have the ability to provide breath samples. That's at the police department.
Okay. And if a person is threatened to have their license suspended, do they really have a choice whether or not they consent?
Objection. Ask for a conclusion.
Well, it's gonna be sustained. You can ask him in a different way, but you can't ask generally if a person, has the right to refuse it, or in light of the obvious consequence, whether he has the, whether he would refuse it.
Nothing further at this time, Your Honor.
Any redirect?
Just briefly, when you first had a conversation with Mr. Swales, did he tell you about his license being suspended?
Objection.
Overruled.
Yes,
So there was a conversation acknowledging that his license was
Objection.
currently suspended
Objection.
Overruled.
at the time? He was already under a suspension?
yes, he advised me of such.
No more questions.
Anything based on that?
No, Your Honor.
All right, you may step
Not
down.
relevant.
Thank you. Next witness?
Thank you, Your Honor.
The state would call Nikki Corfius, and she is, available over the internet. She, thank you.
Thank you.
She was subpoenaed to appear in person here today. She called me this morning and told me she has the flu and sounded quite ill and did not want to expose anyone else. And as a result of this last minute, requesting that she be allowed to testify remotely.
Okay, what's her name?
Her name is Nikki Corfius.
Okay, go ahead. How do you spell that?
It is Corfias. First name is Niki.
Okay.
Let me just make sure there's just one K.
Your Honor, if I may state an objection for the record, we were just given this information today, and just for the record, we would object to the witness, appearing via video.
All right, due to the circumstances, overruled. Ms. Corfius, can you hear me?
Did she say?
Ms. Corfius?
Hello? Can she see?
Well, I don't know, where's that camera pointed?
I have no idea.
All right, I'm gonna have one of them come down here.
or something. To know is told to hit a button, I hit the button. She has no idea where to go. Okay. But can she hear?
There you go, can you hear us? I can now.
Oh, good.
There we go.
Oh, good.
Now, the system needs to be positioned so she can see what? The judge, right here, and the camera position is the thing. Right, yeah, no, a little bit. So,
It's working. Where do you want her to see? Do you want her to see you?
No.
okay, so the attorney to that
Yeah.
position?
Good afternoon.
All right, Ms. Corfius, would you raise your right hand, please, to be sworn in? You swear the testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, Ms. Mulligan?
Could you tell us your full name, ma'am, and spell your name for us?
Nikki Corfias, Nikicorfias.
And what is your occupation, ma'am?
I am a nurse at UH Northwest.
Okay. How long have you been at UH Lake West?
In that position,
Yes.
about 2 years.
Okay. Can you briefly describe your background and training that qualifies you for the position as a nurse at Lake West?
Other than the schooling, we do a 6 to 13-week orientation, and then we are just trained on the job.
Okay. And the school, you have a degree, a nursing degree?
Yes.
Okay. And where's that from?
Northern Career Institute in Willoughby.
Okay. And are you a licensed nurse
Yes.
with the state of Ohio? You hold a,
Yes.
okay. And then when you joined the university hospital system, you said there was an orientation?
Yes.
What is that about? What do they do?
You are paired with like a senior veteran nurse, and you follow them, learn protocols, learn all the on-the-job training that you'll need to be successful in your job.
Okay. And we were talking about your job, I'm going back to January of last year, what area of the hospital were you working in?
The emergency department.
Okay. And do you know, were you working on January 7th, 2023?
I believe so.
Okay,
I don't remember the exact day, but.
okay. And you work, but you have, how long have you been working in the emergency room?
Almost 2 years.
And over the course of the 2 years, have you had the experience of treating patients at the same time there are police at the hospital talking about taking chemical tests?
Yes.
If you could, is that a regular occurrence? Does that happen many times?
It happens pretty often, a couple times a week.
Okay. So, is it correct to say that you have no specific recollection of treating Edward Swales on January 7th, 2023?
That's correct.
Okay. What happens, what is the protocol? Is it for a situation where a medical emergency is taking place, but a police officer wants to collect a sample of either blood, urine, or any other bodily substance?
Well, they have to read, they have their paperwork, whatever that is, that they bring with them. They have to read it to the patient in front of us. The patient has to consent to blood, urine, whatever they're asking for. We make it very apparent they can say no. And if they do say no, then they have to show like the court order that we can get it. If not, then we just don't do it. But if they are a medical patient, we do treat medical first, if that makes sense. So they will be stabilized, we will get any blood or urine that we need to take care of them medically before we do anything for police.
And when you are in this circumstance, what is your top priority?
To make sure the patient is medically safe.
And have you been in the room when the police officer reads a form, telling what the consequences of refusal, or have you've had that experience?
I've never had an experience with the patient refusing, but I have to be present when they read the form, or else I can't do it.
Okay. You said that we make it clear that they have the right
To refuse, correct.
How do you do that?
We tell them that they do not have to say yes, and if they don't, then the police have to provide a court document, or however they call it, for us to get that sample.
Is that
So
your,
as long as they consent to us after that document is read, then we get blood and urine, whichever one is asked for.
okay, and what is the standard and the protocol if they say no? Then
No,
what?
we don't do it.
Okay. But it is your regular practice to ask again, do you want to do this?
Correct.
Do you follow that procedure every single time?
Yes.
Do you recall any time when that was not followed?
No.
If someone said yes and then later said no, one of your patients, would you speak up for that patient?
Yes.
If you believed the patient was being coerced, would you speak up? If you believed the patient was doing it under duress, would you speak up?
Yes.
Have you ever had a circumstance where you've had to say to the police, I don't believe this person is consenting?
No.
do you also take into account the person's ability from a medical standpoint to appreciate the situation?
Yes.
If someone is incoherent, what would your protocol tell you to do?
Incoherent, like they weren't understanding what was being asked of them,
Right.
I wouldn't do it without a court document that I had to.
I have no more questions.
Cross-examination?
Thank you for being here, Ms. Nikki. I represent Mr. Swells, and I just have a few questions.
Okay.
My first question is, in your experience, when a patient has the police in the room, do they ever feel comfortable to say no?
Objection.
Well, I'm gonna sustain it from that standpoint. Ms. Corpius has said that she has no specific recollection of Mr. being there. I mean, you can ask her if she encounters patients who, if she perceives that they are being uncomfortable, what tact she takes from a procedural standpoint, you can ask her that.
Say that one more time.
I think I know the answer to that question.
She's asking you to ask.
No, you can ask another, you don't have to answer the question that was asked, but Ms. Greer can ask another question, okay? So wait for the next question.
Okay.
In your experience, have you ever found that a patient was uncomfortable with saying no when being asked to consent to these chemical tests by the police?
Personally, no. We've had patients that have thought about it or, like asked additional questions, but I haven't had anyone that I felt was uncomfortable saying no.
In your experience, has anyone ever been coherent but under medical treatment unable to consent?
No.
Nothing further for this witness.
All right, any redirect?
No redirect.
All right, thank you, Ms. Corpius.
Thank you.
We're gonna excuse you now.
Okay, thank you.
Do you have any further witnesses, Ms. Mulligan?
No. And subject to the admission, I would move to admit the 3 exhibits that I seem to misplace constantly. That would be the blank form and the filled out 2255, as well as the consent for medical records.
Okay, any objection to the 3 exhibits?
Yes.
What's
I
your
object.
What's
I
your
object
objection to
to-
1?
Well, the medical form, I object to that because there's no witness here that authenticated that form. I mean, the police officer was not the person to produce that form. My understanding that the medical staff did.
Well, what was the officer's testimony with regard to that? That he signed the release, correct? The authorization?
He was testifying about what a nurse did.
Okay. Okay, what's your objection to 2, the 2255 form signed by Mr. Swales?
I would object, I don't recall the witness stating that that was a true and accurate form from the date of the offense.
Okay, he indicated, is there an objection to Exhibit 1, the blank, 2255? Okay, so that's admitted without objection. Exhibit 2, the officer testified that that was the form that Mr. Swales signed after he read him the form. So I'll overrule that, and I'll overrule the objection to Exhibit 3. Does the defense have any witnesses?
No, Your Honor.
All right. All right, you want to argue, Ms. Mulligan?
I would just submit, the state has shown that the consent given was voluntary.
Okay, Ms. Greer?
Thank you, Your Honor. May it please the court. It's obvious that the state would like for this court to focus solely on ability to listen and hear and respond to questions. But when we look at voluntary in the civil law, it's not simply can someone understand. There's a lot other factors that need to be considered. And if we look at State versus Hatfield, 2023, Ohio 4708, the court lists some 7 factors that we need to consider. And not one of these factors has anything to do with the defendant's ability to understand, or whether or not that they are able to be coherent while being read this form. The factors are the suspect's custodial status, the length of detention. Well, the officer admitted that the defendant was not under arrest. However, the officer admitted that he stood by the man's bedside, staring him down for almost 2 hours. There's no way that Mr. Swales didn't feel pressured and threatened to do whatever that officer said. He wasn't leaving his bedside until he did. The other factor is whether consent was given in public or at a police station. We're in a hospital. Again, when we're looking at the factors and the totality of the circumstances, we have someone that's in the hospital. That's much less possible to believe that person is voluntarily consenting in a hospital than, say, at the police station or a public place. The words and conduct of the suspect, we heard the officer's testimony. The suspect slurred speech, incoherent, all these things, but yet he was able to understand the Form 2255 that quite honestly couldn't keep my attention while he was reading it in this courtroom. So I find it really hard to believe that this officer is genuine in stating that this man, while laying in a hospital bed being treated, was coherent and understanding him reading this form. So that goes to the 5th factor, which is the suspect's awareness of his right to refuse consent and his status as a newcomer to the law. Well, if we look at Mr. Swell's record, no, it's not a clean record, but he has had no infractions with the law here. So the idea with the new forms and all that he automatically understood was going on, I think is just disingenuous. And I don't think he was aware that he had a right to refuse being in the hospital bed, all these forms being thrown at him, and he just wants to be treated, he just wants a girlfriend. That's the thing he kept asking for. Another factor the court points out in State v. Hatfield is that, while consent is important, when we see threats of force and, again, this Form 2255, yes, the state of Ohio has allowed for this form to be used, but when you're in your hospital bed trying to be treated for your medical injuries, to force this form onto someone is not voluntary, and is no circumstances under which we can make one believe that this man voluntarily consented. I want to touch a little bit on the Supreme Court and how it looks at the taking of bodily fluids. Now, the Fourth Amendment allows for us to be free from unreasonable searches and seizures. But when we talk about taking bodily fluids, that's the most sacred of the things that we should be free from. And in Birchfield v. North Dakota, which is a 2016 Supreme Court case, the United States Supreme Court, and in this case, the court talks about these forms and how, unfortunately, they're not really allowing for people to consent voluntarily. And I think it's important to read this statement the court says. Implied consent laws do not allow for the taking of bodily fluids. In this case, the defendant submitted to a blood test. After police told him that the law required his submission and his license was then suspended, the court found that voluntariness of consent to search must be determined from the totality of the circumstances. To think that when we're driving our cars on these roads, that we believe that we're going to be subjected to the taking of our blood because we're stopped by the police, this is not what the Supreme Court anticipated that the Fourth Amendment allowed. And the court stated, having concluded that the search incident to arrest did not justify the taking of a blood sample, the court also rejected the prosecution's alternative argument that the state's implied consent laws justify the taking. And that is what the prosecution is leaning on today, the Form 2255, and that Mr. Swales was coherent and able to have a conversation. Again, these implied consent laws just are not valid as it relates to our Fourth Amendment rights. Taking of blood is the most sacred. And Mr. Swales did not voluntarily consent while laying in his hospital bed. So I would ask the court to take into consideration all of the facts, the totality of the circumstances, not just whether or not Mr. Swales could understand and hear, but was he really voluntarily consenting, laying in his hospital bed, trying to be treated, having an officer hovering over him for 2 whole hours. Also, I want the court to consider, what are the parameters of the Fourth Amendment? Does it really allow for the taking of blood and bodily fluids without a warrant? And I would proffer that the Supreme Court in 2016 said no. I would leave that with the court and ask the court to apply the law to the facts.
Is it your contention that the 2255 form, or the execution by a police officer of the 2255 form process, is unconstitutional in and of itself?
No.
Okay. Then, on any OVI stop, when somebody is read the 2255, and they give either a breath sample, a blood sample, or a urine sample, is that unconstitutional?
If they voluntarily consent,
Okay.
I would say no.
All right, so your position is, in this case, Mr. Swales did not voluntarily consent.
That is correct.
Okay.
As well, though, I would, back to the form, though, if the idea is that this form requires him to give consent, that it's implied that he consents to these tests, then I think, again, based on my reading of Birchfield v. North Dakota, that application of that form in that light would be unconstitutional.
Well, why is it implied consent?
What do you mean by that?
I mean, you talk about implied consent. Isn't the status of this that when we sign up for a license, we agree upon, in the proper circumstances, to give a breath, blood, or urine sample, or else the license will be suspended? That's what we're agreeing to, right?
Yes, I think that, based on my reading, I would imagine that that's what the court is saying, and that's what I'm saying as well.
Okay. All right, I'll take that under advisement. We also have a motion that was filed. Let me take about a 5-minute break. I'm going to go find that, and we'll be back and talk about that.
Thank you.
All right.
Yeah. Oh. Be back.
Craziest thing. I'm nervous. I'm like sweating, but I'm cold at the same time.
All right.
See you. All right. There's a defense motion filed today, this morning. Motion to extend deadline for defendant's expert witness report. Ms. Mulligan, did you do that?
Yes, I just got that today. Provided everything that the state has in connection with this case. We have provided digital copies of the photographs that she requested. Those were downloaded back in June 22nd of last year. There was no crash team. There was no analysis of the crash done. There was a crash report. It was provided to defense. There were no downloading of any modules. The state has, again, provided everything that the state has within its possession regarding the discovery in this matter. I believe that this motion to extend deadlines is really just a stalling tactic. It does not have any, there has been plenty of time for defense to explore this. Again, all of the photos and what we do have was sent to her back in June.
All right, Greer, what about number 4 in this motion? What is it that you don't have?
I'm sorry, Your Honor. I didn't print a copy of my own motion. But I can pull it up really quickly. Your Honor, first, I'd like to address the idea that we are trying to stall. I mean, this man is trying to save his freedom. He's not stalling. He's trying to make sure that he prepares a very good defense for a crime that he doesn't believe he's guilty for. As it relates to number 4 here, when we were here on January 17th, I believe, I explained what I meant by the digital copy. So the idea that the prosecution is going to sit here and tell the court that she sent that to me in June when she didn't even know that I asked for it until January is disingenuous. What she gave me was photos that were copied. I asked for the original file because when I spoke to the expert, what he explained to me is that you lose pixelation, you lose the detail whenever you download these photos over and over again. So I asked for the originals. I still don't have those. What I was given in June is not that.
What's the originals?
I don't know, but I would imagine that when the police went on the scene, that's the original. Then they started to send it. It lost some detail when it got sent 3 and 4 times over. Similar to if, again, I were to send you a picture of me right now, and you save it, send it to somebody else. After the 5th person gets it, it's going to lose a lot of detail. So that is what the expert is asking for. As far as the other items here, I was just told today she doesn't have them. So again, this is not a stall tactic. I asked for this back in January. Before the expert was retained, Mr. Swells just paid a retainer on the 31st. And I'm still asking for this information because I don't have it. And it's the expert that advised that this is necessary for his report. Now, if he doesn't have it, we talked about alternatives that he could do what he can with what he has. But today is just the first day I'm being told, we don't have it, and
Okay.
that's fine.
Well,
But that's why we're asking for
it's
time.
it's a prosecutor's obligation to give you in discovery everything they have. So, Ms. Mulligan, you can confirm this or adjust it, but my belief from what you stated is that whatever evidence, whatever documents, whatever, anything you had was downloaded and available June 22nd of '23. Is that correct? Am I correct in?
That is correct, with the exception of the medical records.
Okay.
And I realized on that January 17th date that those had not been transmitted. They were transmitted on that had the medical records since June, but everything else has been since June.
Okay. So what is considered a digital copy of, I mean, I'm envisioning something where the police officer had a camera, took photographs.
I will say, my understanding from the conversation that we had in chambers at the pretrial, I may have misunderstood, but there are photographs that are embedded within the police report.
Okay.
And when we were discussing that, I thought maybe perhaps you don't have the original JPEG files, and that the expert was looking at what was embedded into the report. Well, come to find out, the original, what I consider to be original JPEG files, when it's taken, that's what comes out as a JPEG. Those actually were transmitted back in June. So she does have the most original copy that I am aware exists. I can find out what the make and model of the camera is and see if
Well,
there's
but
anything.
isn't the JPEG the original, the
I'll confirm.
actual photos?
I'll confirm with the expert and make sure that that's good enough. Like he said in here,
Well,
he has the
but
digital photos. Today is the first day I was told we don't have airbag modules and all that. So
Okay,
we're focusing
that's
a lot
not-
on the
that-
photos,
that-
but we're
that's not-
past that.
that's not what I'm talking about.
Thank you.
I'm talking about the JPEG. When those photos are taken, that's the digital format they're in.
Yeah, I would concur, and
Okay.
I can't confirm though that that's what I have, so.
Okay, well, the question is whether that's what was put in the portal.
I can confirm that that was what was sent in a zipped form and was downloaded on the 22nd of June, 2023.
Okay, then you've had it.
What I'm saying is that I gave the expert what I have.
You
He
may-
responded, so I would have to call him and say, hey, those JPEGs, do you believe that that's the original? And I don't have the ability to do that right now. But I'm saying that I appreciate the court and the prosecution taking the time to figure this out about the photos, but that was one factor. There are almost 10 other things that we asked for, and just today, we were told we don't have them. So, again, we're not asking to delay anything. We asked for this back in the beginning of January. She said maybe we have it, but then she only sent me medical records. Today, she's saying she absolutely doesn't have it. That's fine. Now we can move forward.
Well,
But I didn't know that until today.
But according to your motion, the expert wanted these digital copies, in fact, the JPEG, that indicate, that are the original photographs.
Yes.
Okay.
Also, you see number one says what he does.
Hold on, I'm
I
one thing at a
apologize, Your
time
Honor.
here,
I apologize.
okay? So that was the first sentence of paragraph 4, okay? All those photographs, which were apparently downloaded and available June 22nd. Then all measurements taken at the time while on scene or as part of a follow-up investigation, diagrams, calculations, analysis, reconstruction efforts, airbag control module imaging of the involved vehicles. And none of that exists. Is that what you're saying, Ms. Mulligan?
That is correct.
Because none of that, there was no follow-up to obtain those things. Is that accurate or inaccurate?
That is accurate.
Okay. And then the last sentence is, if the vehicles are not available, then the inspection documentation completed before they were released. What is that?
So, in my experience, whenever vehicles are towed by the police, they do some type of inventory, it's taken to the lot, they do some work there, where they take photos. And in my experience, I've had to subpoena those sometimes from the lot. So at this stage, we're asking if any records are in the possession of the state of these vehicles after they were taken from the scene.
Well, I'm presuming they're not, because it's your obligation, the prosecution's obligation, to give you those documents, right?
Absolutely,
Okay, so none of that stuff, does any of that stuff exist?
not that I'm aware of, no.
So then now, this case, the arraignment on this case was October 13th. We had a pretrial October 31st. And at that point, the trial date of January 29th was established. The plea date of January 17th was established. We all were here on January 17th, at which time we discussed these photographs,
And the other,
whatever we discussed, okay? And you indicated to me, Ms. Greer, that you needed until February 9th in order to come up with an expert report, and I gave you that deadline. I gave Ms. Mulligan a deadline on March 1st
if I,
to respond to that, with then a trial date of March 25th. So what's the holdup? I mean, the things indicated in 4 are all, whatever exists is in your possession. I presume that sentence 2 of paragraph 4 are all things that and sentence 3 are all things the experts said they needed in order to complete their report, right?
yes, Your Honor.
Okay, but they don't exist.
Yes, and as of today, we found out that they don't exist. Also, I just want to say, again, we appreciate the court's diligence in the docket. However, it was not our request for the 9th, because at that time, I knew that Mr. Swales needed to give the money to the expert, and I indicated that in chambers. So he did do that on the 31st. We finding out today that there's no additional evidence. So we're just asking that the court allow Mr. Swales to, not having lost his retainer, because the expert, even if there's no evidence other than what we have, they still need the time to produce the report, and they were retained on the 31st.
Okay. And the purpose of the report is what?
So it's my understanding that the prosecution's theory is that Mr. Swales was at fault for this accident, and that's why he's been charged with vehicular assault. We would hope that our expert would show that he was not at fault for this accident.
Okay. So any reconstruction, so it's a reconstruction of the accident scene, right? I mean, that's what it has to be. Okay.
We are hoping to get as close as we can to determine exactly what happened on that date, because clearly we see that there was no investigation done on the scene, no
Right.
police investigation, zero, to determine exactly who was at fault on that date.
Right. So when my experience with reconstruction reports is that an expert would go to the scene, take measurements, whether they're scuff marks, tire marks, debris found at a certain location, whether there were tire tracks in a tree lawn, things of that nature, in order to plot, as well as the speed of vehicles, in order to plot where vehicle went, where vehicle B went, and why they went there, and who caused the injury, right? Is that a different understanding of how these reconstructions work?
This has been my concern since we've been asking for very
Right.
important information that we don't have.
Okay,
So it's
but-
going to be difficult for him to do his job.
Well,
But,
in
yeah.
order for a reconstruction expert to testify, there's gonna have to be a basis of the testimony and underlying data that lead to a conclusion. You just can't throw whatever is out there, and in this case, it's just gonna be pictures taken by the police department after
I think
the
that's
scene had
also,
occurred, but that wouldn't be a basis of somebody to testify as an expert as to how this accident occurred and then determine who was at fault. So
well, I
how is
would
that even
agree, Your Honor.
possible?
I think it's twofold, because these are the concerns I had when I spoke to the expert. So on one hand, the expert can do only what he can with what he has, but he is also an expert in understanding the proper procedures
Well,
So
but the
this man is
procedures-
being accused of doing something where no investigation was done into
Okay,
how it happened.
Hold on, let's,
So-
you,
I think,
So,
I can't testify
why-
about how it's supposed to happen.
why
but he
would
did.
an expert in reconstruction be permitted to come in here and say, the police didn't do A, B, C, or D at the scene, or you know, E, F, G, and H as a follow-up, therefore, they can't prove Mr. Swales is at fault?
No, I think it's twofold. So first, you have the expert who we hope can produce a report that can show who was at fault. I know he has very limited information, but as an expert, that's something that he will have to decide. He was retained, and he knew that the possibility is that that didn't exist. On the other hand, though, no one else can testify but an expert, I would say, for the defense as to the procedures that are proper in these circumstances. So I get, you know, that the court may not like that that's the way that we have to go
Well,
possibly.
why is it
but-
relevant as to what the procedure is?
Well, it's relevant because,
Because you're talking about the procedure of evaluating a car crash, right?
that's correct.
Okay, so let's say that he came in and said the proper way to do it is to take pictures of the final resting place of each vehicle, the entire roadway within a certain distance of each vehicle, pictures of the entire ground in a certain parameter around where these vehicles are. And then whatever follow-up is required to further investigate. That's the proper procedure. And if when you cross-examine the prosecution's witnesses, they're gonna say, we took pictures of the cars, that was it. We didn't take pictures of the roadway, we didn't take measurements, we didn't do any of that stuff, okay? So if your guy comes up here and says that, what's the relevance of that?
So the relevance is that it will lead the fact finder to determine whether or not there is reasonable doubt to believe that this man is actually the cause of the accident. Unless we can put on a defense, which the only person we could call probably is an expert. My client's not gonna testify.
An expert
The two
in what?
victims are not gonna testify. An expert in accident reconstruction. I don't know what the man will come up with. And I talked to him a couple of days ago when he was retained, and we talked about the possibility that all the things he's asking for may not exist. And I said to him, you may have to figure out how to do it without that. So that's his duty, as to determine whether or not he can decide who was at fault.
It's my duty,
But
all right, it's my duty, number one, to determine whether what I presume you won't bring him in here to testify unless he can conclude that
Yeah, and
the
we
other
don't
car,
know yet.
that the victim's car was the cause of the accident, right?
that's true.
Okay.
That's what we hope that
So
would
if he
say.
doesn't have the underlying data, talking about the points I talked about early on, gouge marks, tire marks, physical property damage, then he's not gonna be able to opine.
Well, he can opine that these people, so who evaluates the police and their investigations, and whether or not
Okay.
that they do things the right way?
Okay?
We just allow ourselves to cross them and hope that the jury can deduce that they did something wrong?
Well, what-
So I'm
you-
saying
you
that our
have the-
expert,
you have
our
the abi-
expert,
You have the ability to call, you have the ability to subpoena the head of the crash reconstruction on the, and the entire Lake County and say, what's the proper way to do a investigation, a crash investigation? A, B, C, D, and E. And you have already cross-examined
I understand,
the
but
officer
that's,
that said, did you do this? No. Did you do this? No. Did you do this? No. Okay? And then you can argue. But a crash reconstructionist, without having underlying data, is meaningless, because he can't offer, I'll never let him get to an opinion if he doesn't have the underlying data.
I understand. So I may have to file a motion then, as it relates to the prosecution failing to preserve evidence that could exonerate this gentleman. And that's probably my next step. But I appreciate what the court is doing here, and these are concerns I had when I talked to the accident reconstructionist. And I think that is very horrible that the police would fail to do an investigation, and this man is about to almost face 2 years of his life in jail, and we have no clue.
Well, let's not get ahead of ourselves, okay, because in every crash, so what you're saying, in every crash that occurs, there has to be the crash investigation unit, which is a very specialized process. I mean, the crash reconstructionist, as you know, because you want to hire an expert to do it, is very particular. There has to be specific training as to how you do that, what you look for, what you find, how you conclude, what you base that conclusion on. Okay, so in every crash that occurs at any time, is it your contention there should be a crash reconstruction?
I think anytime you're going to charge someone with vehicular assault and put them in a position where they will have to spend 2 years of their life in jail mandatory, that you should have evidence to support that they actually did that.
That may be a good policy to institute, okay, but does policy equate to, what does that policy, what does that lack of policy, what does that mean to a criminal case?
That means that a lot of people are convicted with very limited evidence,
Okay.
and then they're not allowed to put on a defense that would point to that limited evidence. So,
Well, you can put, I mean, you have the perfect ability to stand up with a big megaphone and talk about, and it happens in almost every criminal trial, about what they didn't do and why they didn't do it, and get at them as to why they didn't do it and what that might have meant in the larger context of things, right?
I think the expert just will have a lot, like the weight of their testimony is much better than my cross-examination or my wowing someone with my opening or closing. I mean, they're a witness. They can testify and speak to, based on their expert opinion, what is or is not in this case. And I don't know exactly what that opinion would be, but I know they have to get paid before they give you one. And I'm just hoping that the court will take that in consideration, because this gentleman and his family came up with the money to pay the man. We would like to at least have the opportunity to let him do his job.
Okay. I'm just not sure, his job, he's not gonna be able to offer an expert opinion on what the police should have done, okay? He'll be allowed to offer an expert opinion as to what, in your case, in the case of a reconstructionist, what the cause of the accident was, if he has the underlying data to come to that conclusion. He can't come to that conclusion without the underlying data. So it seems to me that in every crash reconstruction report and testimony and case I've been involved with, then unless you have the underlying data of scuff marks, of tire marks, of damage at the scene, of damage on the two cars as they're related, you can't come up with that opinion under any scenario.
So the prosecution cannot preserve the evidence and then give this man the opportunity to present an expert.
The prosecution, Ms. Mulligan's office, doesn't get involved in this case.
They don't preserve evidence.
Well, you're talking about preserving, okay? And the
Police
implication,
do, I'm sorry.
the implication is they knew something existed and got rid of it, okay?
Mm-hmm.
But the police do their investigation. The police then issue a charge in where was this accident? Eastlake, in municipal court, in Willoughby. Then the case apparently got bound over here. Then it comes to her office. Okay, so what was done was done. So your complaint is with Eastlake Police and not doing an accident reconstruction, right?
No, not preserving the evidence either. Where are the cars? Where's the airbag modules? My expert has done other cases in Lake County, and in his experience, when it's fair to the prosecution, they'll do it. Maybe if somebody dies, then they decide it's worth it.
Okay, so
But I just don't see why they are
so
picking and choosing to
the accident
do their job.
reconstruction team should have done it. They didn't do it. because it
I mean,
didn't
I think
benefit
the
the
city,
prosecution?
like, we are charging a man
I understand,
with a
I
very,
understand that.
very,
Understand
very, like,
Okay.
I mean, it's his freedom
So
on the line.
is it your contention that they didn't do a reconstruction because it didn't favor the prosecution?
I mean, that would be a nice theory, but it was not the one I was thinking of, Your Honor. I was thinking that, you know, like a lot of times we see they just don't take the time. It's not important to them. But it is for somebody that's facing going to jail for
Okay.
years.
So then what are you asking to be done because they didn't?
I mean, I don't
do a
think we should be able to, like, if we don't have any evidence to determine who's at fault, then how can we say who's at fault?
Well, that's the purpose of the trial. They're gonna put on evidence. They're either gonna be able to.
Yeah, their evidence is gonna be two people
Okay.
saying that somebody else did something because it benefits them.
I don't know what the evidence is.
The police
but
cannot prove
hold on.
who's at
We
fault.
can't both talk
I
at once,
apologize.
okay? I don't know what the evidence is, because the only thing I know about this case is been in the last 2 hours, okay? So I don't know what the evidence is. If they don't have the evidence, okay, then they don't get a conviction, right?
That is true, Your Honor.
So I'm not inclined to grant your motion, okay, because there seems to be, the things that your guy needs in order to come up with an expert opinion don't seem to exist. Now, if you can give me some information otherwise from your expert, if you don't, to the extent that in order to do a proper reconstruction and to offer an expert opinion, I need A, B, C, D, and if they don't exist, he can't do it.
Yeah, I think the things that you have mentioned in court today have not been the specific things he's asked for. However, maybe he presumed they were in those, parts of the evidence he asked for. So, I mean, my client has already paid for him to be retained. I think that is my biggest concern, is just his family losing out on paying a retainer for someone. If that expert just, I don't know what he can do with what he has. And, you know, I understand that the court's gonna be scrutinizing that, but to not give them the opportunity to move forward
Okay,
with
but-
something like this is, I think, just detrimental,
But-
because
but-
they've gotten this far.
But a full accident reconstruction, which you're asking me to give you 4 to 6 weeks for him to do this.
Based on what the expert asked for, and I have to lean then on the court, yes, that is what we're asking for.
Who is
because,
who is the expert?
Terry McMullen, I'm not looking at the document right now, but I've talked to him several times. I've researched him. He's local. He has a pretty lengthy resume. So, I think he's qualified, and my client just was able to pay him.
He may very well be. The question is
Mhm.
whether he has the data to come up to that conclusion by to give.
But the court at least gives me opportunity to speak with him. After we've spoken today, I could
Well,
better respond to that.
I want you to speak with him, and if you're gonna file anything
Yeah.
in addition to this, it's gonna have to be what data is required, and because you have all these photographs, okay? What other data is required for him in order to offer that expert opinion?
I'm more
Okay?
concerned if what he has is all that he can get, can he, with them having already paid him? That's my biggest concern, to be quite honest.
Well, he has what exists.
Yes.
Okay, so with what exists, does he have the underlying data to reconstruct the accident such that he can issue an opinion as to the cause of the accident?
Yes.
Okay? To me, it's that simple. Okay,
Yes.
now, if the guy took money and he can't produce a report because he doesn't have the data, then he ought to give the money back.
That's what I want to try to address,
Okay.
if, yeah.
You know, because then, if he says, well, too bad, then I gotta wonder about, kind of business he's running, okay?
Yes, yes.
So if you can supplement this
Yes,
and tell me, then I'll consider it, but he's gotta come up with specifically what he needs in order to do that, and if it doesn't exist with what the state has produced, because what they produce is what they have, then there's no point to it.
okay. That is due in 1 week. Is the court inclined to give any continuance today to at least give me time to figure that out and submit
Well,
something?
I want you to submit something within the next few days.
Yes, sir.
Okay, because seems to me that's that guy's obligation to you
Okay.
or to your client, since your client hired him, okay?
Okay. So before the deadline, you would consider,
Yeah.
even if it's less
Well,
than a week before?
I want you to, your deadline is next Friday, so.
Yes, sir.
I'd like something by, like Wednesday that says, from McMullen, says, I need this, this, and this, and if that doesn't exist by virtue of what has been provided, then
What if
there's
he
no-
says he can do his job with what he
Well-
has, and he just needs time?
Okay, if he can, what pictures exist? Do you know offhand?
They're JPEG pictures of the automobiles the night right after they
Okay,
collided.
so are there a lot of pictures, or?
Not a lot.
Okay, so I think what I want you to do, okay, if this guy's gonna contend that he can come up with a conclusion, a reconstruction conclusion, causation, based on those pictures, then I guess we'll probably have a hearing with those pictures, and I wanna know how he can do that in the context of a accident reconstruction leading to a causation.
Ask the court a question.
Yeah.
Because, I'm inclined to believe that the court would conclude that if the expert does not have the measurements and the skid marks and those things, that they cannot give an opinion.
Right.
Okay.
I mean, because that's the nature of accident reconstruction.
And if I-
It's determining, as this car was coming this way, and this car was coming this way, based on this mark on the road, this damage here, the way the vehicle's hit, that, this car was at fault. This car caused the accident, not the defendant's car causing the accident.
I agree. I can't disagree with the court's, statement there, but I guess if that is the case, and we know, let me ask this question. Is that evidence only, able to be obtained at the scene? Or does the court believe that skid marks and all these other things can be depicted in a photo?
I mean, it's depicted in photos all the time,
Okay.
in conjunction with an accident reconstruction team, then going and getting out the walking tape measure and measuring point A to point B to point C to point D.
I'm
So,
inclined to believe the court doesn't think that he has what he needs.
that
I don't
those
think
things
that-
don't apparently exist.
Yeah.
Okay? And it sounds like the photographs aren't concentrated on going, 100 feet in advance of where the stopping point was and getting this, that, and the other thing. It doesn't seem to exist. Now, I may be wrong, because I haven't seen the photograph, so I don't know, okay?
Okay.
So, by Wednesday, get something that convinces me that this should be extended, all right?
Thank you, Anna. Can you please resend everything? Because you're saying a lot of things are like, timed out, and so I don't
I'm
wanna.
not saying a lot of things are timed out. I'm saying what we sent you on the 17th, I think it was the medical records, whatever we sent you last, we will resend that.
I don't want the medical records in, because I have those. So I just would like for you to resend the link, because I thought there was other